providing state-of-the-art facilities to set up every kind of convenience to facilitate international and domestic arbitrations in this region to be conducted at the center, which is self-regulating, has its own regulations and empanelment for arbitrators. The step forward was to take up the erstwhile institution, which is now housed on a vast plot of 5 acres of land in South Delhi, having complete amenities and facilities for parking, for conducting arbitrations, etc.
In the last decade, there has been a sea change in the landscape of Indian arbitration. Government has undertaken several measures to address bottlenecks in dispute resolution. Our courts have, through their judicial pronouncements, systematically promoted a pro-arbitration regime. The IIAC has all the requisites necessary to establish itself as a premier arbitral institution. It has state-of-the-art facilities, rules and regulations consistent with best global practices, guidance and inputs of distinguished experts, and most importantly, a pool of experienced and credible arbitration professionals across disciplines.
The India International Arbitration Centre is the only institute set up by an Act of Parliament. The centre is declared to be an institute of national importance to promote domestic and international arbitration in India. We have state-of-the-art infrastructure for dispute resolution, from spacious meeting rooms to cutting-edge video conferencing facilities. We are equipped to deal with all kinds of dispute resolutions in efficient and professional manner. We have a pool of arbitrators bring wealth of expertise and insight to every case they handle. The reservoir of legal talent is unparalleled in its expertise. The centre is located close to the airport and near important commercial and business centres in the capital. India is marching towards creating an independent and autonomous regime for institutional arbitration.
In line with its objects and functions, IIAC strives to conduct arbitration and other forms of alternate dispute resolution mechanisms, both domestic and international, as per the manner specified by its regulations. Further, Chamber of Arbitration has also been established to empanel arbitrators, both domestic and international, as per the empanelment regulations.
The establishment of the India International Arbitration Centre marks a significant milestone in India's pursuit of global recognition as a prominent player in the field of arbitration. This will not only affirm the nation's standing in the international arbitration community, albeit IIAC as an institution will foster a sense of trust and credibility among both domestic and international parties engaging in arbitration within India. I hope the IIAC will emerge as a credible frontline institution in providing a dedicated and specialized platform for arbitration and will enhance the accessibility and efficiency of dispute resolution in India.
Debates about streamlining the process of commercial disputes have been going on in India for quite some time. And the intense international competition among nations to prefer their own centers of international arbitration was another subject. But now India has launched a major initiative taking stock of both these aspects.
The India International Arbitration Centre is managed by a team of eminent persons having substantial knowledge and experience in institutional arbitration at both domestic and international levels. The Chamber of Arbitration will empanel arbitrators from amongst the persons who are proficient and willing to serve as arbitrators based on their expertise and experience. The panel of arbitrators includes both experienced as well as young professionals. The Centre has an efficient secretariat to administer arbitration under a progressive set of the conduct of arbitration regulations.
There has been a paradigm shift in the traditional mindset of ADR mechanism, especially in the arbitrations. And when we talk about institutional arbitrations, IIAC has indeed taken the front lead at the national level.
The vision of India International Arbitration Centre is to promote the overall alternative dispute resolution mechanism from the grassroots level with an aim
intensely debated and as keenly felt as the role of institutional arbitration. For decades, India has grappled with the questions of efficiency, credibility, and global competitiveness in its arbitral framework. The move from ad hoc to institutionalized systems has often been described as the next big leap. Yet, it is a leap that demands both legal reform and cultural acceptance. Recent policy decisions have added a fresh urgency to this conversation. The Ministry of Finance, through an office memorandum dated June 3, 2024, directed that in domestic public procurement contracts, arbitration should be restricted to disputes below 10 crores. For disputes above 10 crores, the circular envisaged an approval mechanism. Notably, the directive also emphasizes institutional arbitration as the preferred route over ad hoc proceedings whenever arbitration is chosen. This was, of course, informed by the PSU's experience with arbitral awards in the recent past. The motion for today's event is informed by this recent discourse, which has made a case for institutional arbitration as a preferred mode for contracts involving PSUs. The motion being, this House believes that institutional arbitration is the complete solution to restore the faith of PSUs in arbitration as the preferred mode of dispute resolution. Now, before we get up for the debate, as we know, it's an Oxford-style debate. So to keep things exciting, before I invite the jury and the speakers on stage, I would like the audience vote through a show of hands. So everybody who is in favor of the motion, and I will repeat the motion again, this House believes that the institutional arbitration is the complete solution to restore the faith of PSUs in arbitration as the preferred mode of dispute resolution. Those in favor, please raise your hands. Okay. And those against the motion, please raise your hands. Okay. So the choice is pretty clear. I now take this opportunity to invite, to first introduce our jury and then invite them on stage. The August jury comprises of Honorable Justice Hemant Gupta. Justice Gupta is also the chairperson of IIAC. Honorable Justice Gupta has dedicated over 2 decades to the judiciary, serving as the Chief Justice of Madhya Pradesh and Patna High Courts, and as a judge of the Honorable Supreme Court of India. As the chairperson of IIAC, he is driving India's vision to become a global hub for efficient domestic and international arbitration. We've witnessed his tireless efforts to position IIAC and India on the global arbitration ecosystem. Please join me in welcoming Justice Gupta to the stage, please. Justice Gupta is joined by Honorable Justice Devendra Kumar Upadhyay, Chief Justice, High Court of Delhi, as the of distinguished judicial experience. He has previously served as Chief Justice of the Bombay High Court and as a judge of the Allahabad High Court. Renowned for his expertise in civil and constitutional law, he has significantly shaped Indian jurisprudence through landmark judgments and judicial leadership. May we please have a huge round of applause. And finally, joining the illustrated jury is Dr. Anju Rathi Rana, an Indian legal service officer as an additional public prosecutor handling major criminal trials for over 18 years before pivoting to the field of policy. In 2017, she moved to the Ministry of Law and Justice as the Joint Secretary and later promoted to the position of Additional Secretary in 2022. Over the years, Dr. Rana has taken on several leadership roles, shaping India's legal framework and capacity building initiatives. Please join your hands to welcome Dr. Rana on the stage. We could not have envisioned a better jury for this session. Now, with the jury's presence on the stage, please join me in inviting Honorable Justice Hemant into simple propositions. His contributions to arbitration practice have been recognized both in courtrooms and in institutional forums. Please give a huge round of applause for Mr. Chinappa. It is my pleasure to next welcome Mr. Rajshekhar Rao, senior advocate practicing in Delhi. Mr. Rao is a distinguished litigator with decades of experience in civil, commercial and arbitration matters. An alumnus of NLSI Bangalore, he began his career with trailblazers like Ms. Indu Malhotra and Mr. Gopal Subramaniam, and was designated as a senior advocate in 2021. During his tenure with Mr. Gopal Subramaniam, Mr. Rao worked on pivotal cases related to the Tehelka Commission as well as the Parliament attack case before the Delhi High Court. Outside the courtroom, Mr. Rao is an avid photographer, and we get to witness the union of his legal and creative passion through his photography page. Please give a huge round of applause to Mr. Rao. And finally, joining the stellar team for the motion, I now welcome the final speaker, Ms. Manini Brar. Ms. Brar is an accomplished advocate and arbitrator specializing in civil, commercial law and arbitration. A Cambridge postgraduate and a fellow of CIRB, she has advised the Government of India, served as amicus, and contributes actively to arbitration policy, academia and practice. Manini is also empaneled with institutes such as IIAC, SIAC, THAC, etc., and serves as a member of the ICC Commission on ADR. She sits on the editorial board of Young ICA and has published extensively on premier arbitration platforms. Personally speaking, in addition to her brilliance as a lawyer, I look forward to her column, The Arbiter Truth, where her wit and humor shines through. Given her association with both the government and the arbitration ecosystem, we look forward to hearing her perspective for the motion. Please welcome Manini on the stage. On the other side of the debate, we have an equally eminent panel of speakers who will argue against the motion. Joining Team B, which is against the motion, first we have Mr. Akshay Bhan. Mr. Bhan is an alumnus of National Law School of India, University, Bangalore, and was designated as a senior advocate in 2014. He hails from a family of distinguished lawyers and judges. His father, Honorable Mr. Justice Mr. Ashok Bhan, was a distinguished judge of the Honorable Supreme Court of India. Over a period of more than 24 years, Mr. Bhan, can we have a huge round of applause for Mr. Bhan? Mr. Bhan is joined by Mr. Jayant K. Mehta. Mr. Mehta is a designated senior advocate by the Honorable Delhi High Court with over 24 years of experience in commercial, civil and constitutional litigation before the Supreme Court, High Court and various tribunals. An alumnus of National Law School of India, University, Bangalore, he has been involved in several landmark cases shaping Indian jurisprudence in arbitration, etc. He has also appeared in numerous domestic and international arbitrations, both as counsel and as sole arbitrator, including his empanelment with the Delhi International Arbitration Centre. He has been appointed as an amicus by the Supreme Court and High Courts and continues to contribute through pro bono work and judicial training. Please give a huge round of applause to Mr. Mehta. And finally, joining the team against the motion is Ms. Payal Chawla. Ms. Chawla is the founder of Just Contractors, a Delhi-based all-woman full-service law firm specializing in commercial transactions and disputes, particularly arbitration and corporate law. Payal has been named as one of the thinkers to watch out for in 2015 by the Forbes India. She was named as the Corporate Lawyer of the Year, India for 2016 by Corporate Livewire Legal Awards and the Partner of the Year by Annual IDEX Legal Awards. In 2019, Just Contractors was photographed by Ms. Lynn Johansson, a Pulitzer nominee photographer for the National Geographic as part of the celebration of 100 years of the US suffrage movement. Ms. Chawla was recently featured as part of the Jaipur Writers' Shorts at Jaipur Literature Festival. Please join me in welcoming Ms. Chawla on stage. Please give a huge round of applause for all our speakers to encourage them there after the debate. Before proceeding further, I've been entrusted with the responsibility of outlining the rules of the debate. So we've already taken a vote by the raise of hands in the beginning. Now the two sides will argue. Team A will speak for the motion and Team B will speak against the motion. Each team has 30 minutes in total to allocate amongst its speakers as they see fit. Team captains may decide both the order of speakers and time each speaker will take. Speakers will alternate between teams. Speaker 1 of Team A and then Speaker 1 of Team B, followed by Speaker 2 of Team A and then Speaker 2 of Team B, and finally Speaker 3 of Team A and then Speaker 3 of Team B. After the main 60 minutes, each team will have 5 minutes for rebuttals. One speaker from each team chosen by the team captain will present the rebuttal. Team A will present first, followed by Team B. Members of the jury and the audience may pose questions once all the speakers have delivered their arguments and rebuttals. There will be another round of voting at the end of the debate to see if the teams have been able to swing the votes in their favor, and then of course the final word rests with the jury. With this, I open this floor for the debate. Please give a huge round of applause.
Respected members of the jury, my fellow speakers, ladies and gentlemen, this is not the motion for today. The motion for today is, this House believes that institutional arbitration is the complete solution to restore the faith of public sector undertakings in arbitration as the preferred mode of dispute resolution. And I think without really any further ado, the motion must pass, because isn't that really obvious first? And secondly, isn't that practically a lot of what we do professionally, either appear for PSUs or against PSUs, and we don't want to lose arbitration of PSUs going into courts. Therefore, what I would think is that I'm now giving you additional justification for why this motion must pass today. Let me give you 3 case studies that is experiences of my own. The first, in an arbitration involving a judge who was the arbitrator, the contract was for a sum of rupees 30 crores. The claim was for about 100 crores, and there was no evidence. The arbitrator held for each of the claims that the claimant has not led evidence, but I think it is fair to award 5 crores where the claim was 10 crores, 10 crores where the claim is 20 crores, and 15 crores where the claim is 30 crores. First case study. Second, an arbitral tribunal decided that since the respondent did not pay their fee, they must award the entire claims of the claimant. Of course, the award got set aside subsequently. The third case study, a 3-member high-powered arbitral tribunal summoned the managing director of the respondent, demanding as to why the respondent had not paid their fees. There is only one common thread in all of these cases. The respondent was a public sector undertaking. So when we wonder why public sector undertakings have lost their faith in ad hoc arbitration, the answers are quite startling. When arbitration really took off in India, we believed that the absence of rigors of court and of procedure, the release from formality, the hope of low costs, of timeliness, of its binding nature with low interference by courts were the joys that arbitration was to bring into India. Arbitration Act aspired for those goals, yet time has proven the contrary. Ad hoc arbitration is ridden by procedural formality, skyrocketing costs, no control on timelines, and interference by courts continue unabated. And the biggest litigant is at the end of receiving all the difficulties from this. One must never forget that governments and public sector undertakings account for almost 70% of arbitrations in India. And when it is 70%, they are always at the receiving end of ad hoc arbitrations. Which is why the 2024 guidelines which came in echoed this frustration and said and really demonstrated a hasty retreat from all high-value arbitrations. Though the 24 guidelines speak of mediation, we know in practice that mediation is seldom successful when it is at the initial stage of the dispute and there is arbitration to then follow. But why this strategy retreat? Why have so many governments and public sector undertakings already given effect to it? Oil India, ONGC, the PWD Department of Delhi and of Karnataka have all moved towards removing arbitration clauses from their contracts. That all public sector undertakings had contracts which had arbitration clauses where they would appoint the arbitrator, or their managing director or general manager would be the arbitrator. Now, Supreme Court said, and the law changed, and you couldn't have an arbitrator who is connected to a party. Absolutely important, because ultimately arbitration is a mechanism by which disputes have to be resolved impartially and by an independent arbitrator. But that's not really the issue here. The real issue is inefficiency of ad hoc arbitrations. There are issues of cost, timelines, and quality. The Act prescribes 18 months to complete an arbitration, yet courts extend timelines endlessly. Costs have skyrocketed for counsel and arbitrators. Day-long arbitrations do not really last that tenure. Awards lack any oversight. Shoddy awards, short of reasoning and logic. Failure to apply the law and facts properly is the order of the day. And what I have designated certain arbitrations called feeling arbitrations. These are not awards which are delivered on the basis of facts and of law. These are awards delivered on what I feel, out of sympathy and compassion. And I'm sure many of who practice in arbitrations have seen awards which say, there is no evidence, but I feel it is fair and just to make an award. Or there is no evidence, but he must have suffered a loss. And there are number of instances where this constantly happens. And these are factors which ultimately influence or must have influenced the government in coming out with a resolution of this kind. But really, these are the problems. But how do we find a solution to it? We have looked today at the most obvious difficulties, but how can to say that all disputes must go back to courts? That will set the system back by decades. This effect, of course, won't be noticed now. You will notice the effect in the next 3 years. With arbitration, after all, it's the most effective and efficient dispute resolution mechanism. The problem is with how it is run. What institutions can do which ad hoc arbitrations cannot. I'll take something very fundamental. And to me, this is the most fundamental aspect of arbitration. The most fundamental aspect of arbitration is the appointment of an arbitrator. And when we say arbitration is founded on consent, it is founded on consent because it is founded on a person being designated by both the parties to the dispute as the arbitrator of their choice. But today it does not happen. If I designate a name or nominate an arbitrator, the respondent will refuse it. And if the respondent refuses, I will, or nominates someone else, I will refuse. And we all end up in a Section 11 proceeding. In a Section 11 proceeding, you must appreciate that judges are not assessing the nature of the dispute, the nature of the claims, the parties, and then making a determination as to who the arbitrator should be. It is seldom a scenario, at least in my experience, that the judges have the time to actually examine all disputes and then decide as to who the arbitrator should be. Maybe some do, and my apologies if I have in any way offended His Lordship. But practice, at least in my state, I have found the contrary. Having said that, what institutions can do is this. Institutions have the time, institutions have the resources, institutions have the claim before them which they can then assess and determine as to whether a particular arbitrator is best suited. And I'll tell you the second thing which a Section 11 court can't do. A Section 11 court does not have the benefit of examining awards of an arbitrator who is designated. An institution can. If an arbitrator has been part of an institution and there are several awards of that arbitrator, the institution can decide as to whether that arbitrator is capable or not of making a proper assessment of the facts in a particular case. Therefore, of course, we made a suggestion of this kind to the Karnataka Arbitration Centre, but it either was met with giggles or a laugh because most of the arbitrators there were judges, and there was no one who had the courage to say, I'll review his award and then decide as to whether he should be an arbitrator or not. The next obvious fact is cost. I'm not a great proponent of the argument that costs are reflective of arbitration being unsuccessful. It's not really cost, but it is of cost being known at the beginning, which an institution does. Because you know at the beginning of the arbitration as to what your total cost is. But in an ad hoc arbitration, that is never the case. Hearings can go on endlessly, and with a sitting fee day after day, you are in a scenario where everybody is uncertain as to how long the arbitration will last. If you have to make an application for extension of time in a court, a party must make that request. If you have to make a request to an institution, the arbitrator must make the request. And when an arbitrator has, this is a good example because when we did an ICC arbitration, the arbitrators were extremely concerned because they would have to make a request and justify the extension of time. And therefore, the arbitration moved faster. And timelines have an important factor to play. It ensures that interest rates are limited. It ensures that you have a timeline and therefore you know when the arbitration will get over. Ultimately, all of these are costs to a PSU. And these costs, in my opinion, are extremely vague when you have a scenario of an ad hoc arbitration. That is where an institution comes in and solves the problem. Well, to really summarize, going back to courts is not an option. Mediation is seldom final in practice. Ad hoc arbitration is out of the question. Institutions which rise up to the occasion, centers like the MCIA, DIAC, IIAC, and several such institutions have to provide for a robust appointment procedure, a fair and comprehensive cost regime, a review of all awards, not to alter the award, but to use that as an effective mechanism to eliminate arbitrators who do not meet the necessary standard, and of course, at the very end, effective enforcement in court. That, in my view, will bring back PSUs into the arbitration fold. Thank you very much.
Honorable Justice Mr. Upadhyay, Honorable Mr. Justice Prasad, Honorable Justice Mr. Hemant Gupta, Dr. Rana, respected judges both sitting and retired, my fellow lawyers, ladies and gentlemen. To claim that institutional arbitration is the complete solution for restoring PSU faith is to pass judgment without trial. In fact, even without framing the issue. The question we need to ask ourselves is why have PSUs lost faith in arbitration? And the more important question, is the loss of this faith even justified? But where would we look to find the government's point of view? We don't need to look any further but to just see the government statement in the memorandum dated 3rd of June 2024. The memorandum tells us much in plain terms, and even more by its silences. According to the memorandum, arbitration has failed to deliver on its core promise of swiftness and cost effectiveness. But let's test this claim for institutional arbitration. Can we seriously argue that institutional arbitrations are more cost effective than ad hoc arbitrations? Obviously no. And this cost is exacerbated in cases where they're of high-value disputes. For PSUs under budgetary strain, this creates a structural disincentive. Push them too hard, and PSUs will move towards litigation. And that, my friends, will be the death knell for arbitration. Consider what that shift would mean for our already overburdened courts. Even as I speak, there is a petition pending before the Supreme Court seeking a mandamus against several states to implement the provisions of the Commercial Courts Act. With mounting dockets and scarce judicial time, can our courts truly cope with a painstaking appreciation of complex evidence? Yes, undoubtedly, institutions have set rules, case management protocols. But are their delivery timelines better than ad hoc arbitrations? Perhaps, but that evidence at best is anecdotal. The memorandum goes further to say, and I quote, "Reduced formality combined with the binding nature of awards are what the government says the reasons for the error and in fact and law in arbitral awards." Isn't that a sweeping generalization? I would in fact go so far as to say it's patently incorrect. Reduced formality has made adjudication faster, not slower. Both institutional and ad hoc tribunals are equal opportunity offenders when it comes to formality. Neither mirrors the CPC or the Evidence Act. So long as parties, especially PSUs, continue to pursue their statutory remedies under Section 34 and 37 indiscriminately, sometimes even dragging matters to SLPs and curative petitions, the promise of speedy resolution will remain illusory. Some of the most high-profile judicial interventions have involved institutional awards. DMRC versus Dampel, where the Supreme Court interfered even at the curative stage. And then there is the Antrix and Devas dispute, where the Delhi High Court set aside an ICC award. Institutional arbitrations do not provide immunity from interference. Institutional rules cannot immunize awards from the chronic delay of litigations. And this, my friends, contrary to popular belief, is not limited to India. And then there is another very telling sign in the memorandum. It actually recommends mediation over arbitration. Now, many of you may say that that is just a case of drafting having a bad day, or even worse, it could be a Freudian slip, betraying the government's true intentions for litigations. Could it be that they want to take advantage of the inherent delays in the system, cloaked in a different name? Either way, one thing is clear. Institutional arbitration cannot on their own rescue arbitration. Now consider the paradox. The very government that ushered the landmark amendments in 2015 to make India into an international arbitration hub now discourages PSUs, the country's largest litigant, from arbitration. Unless the government embraces arbitration in its totality, its own faith cannot be restored because real issues are structural and inherent within the government itself. It is no secret that PSU officers face personal risks in accepting adverse awards. The risk of audit scrutiny, vigilance inquiries, even the charges of impropriety. By contrast, the safest bureaucratic choice is always to appeal, regardless of merit. It's the path of least resistance. Pursue one appeal after another in the hope of tariq pe tariq. But somehow, this blame always falls at the doorstep of arbitrators. Because, why not? It's easier than admitting that the facts were weak, or we were simply not up to the task. Wrongly or rightly, there are concerns about integrity, accountability, and competence of arbitrators. But unless we are willing to face the truth, how will there be any change, whether the appointment is institutional or ad hoc? First and foremost, the government must bring reform at a policy level and see arbitration as an economic driver of growth. A thriving arbitration hub means foreign revenue, more jobs for lawyers, the development of ancillary businesses such as conference facilities, transcription, translation, research support, hospitality, legal tech. For this, there is no need to discriminate between institutions and ad hoc arbitration. Second, we must be honest with ourselves. Today, 90% of the arbitrations in India are ad hoc, pretending that we can flip this switch and overnight do it and somehow make institutions the only route, in my humble submission, is unrealistic. Third, the government must confront the elephant in the room. Arbitrations are lost because of bad facts and weak legal representation. It has nothing to do with ad hoc and institutional arbitrations. PSUs must seek the best legal representation and should not shy away from paying lawyers top dollar. This will also assist in developing the legal market, creating access and the confidence to compete at the global stage. The memorandum proposes the creation of a high-level committee to oversee, negotiate, and mediate high-level disputes. without giving it any real authority. Such a committee would be akin to a toothless tiger, adding another bureaucratic layer to delays. What is truly needed is to empower PSU officers to settle unmeritorious claims by providing them with adequate protection and incentives. Fifth, we must resist the urge to expand the court's powers under Section 34. Please take note that in the UK, its recently enacted Arbitration Act 2025 has significantly narrowed the scope of judicial intervention in arbitral awards, and this has been done in order to remain competitive. India cannot and must not move in the opposite direction. If we truly want best-in-class arbitrators, we must invest in accreditation and training, perhaps through judicial academies with specially crafted courses. Let me end by saying that I do not denounce institutional arbitration. Quite to the contrary, I am a strong proponent of it, but it is not a remedium universale. Ladies and gentlemen, let us not settle for interim or partial measures. Let us insist on a final and binding resolution. I therefore urge you, and emphatically, to reject the motion. Thank you.
Numbers to support the debate, and of course my co-speakers. This is an interesting topic because the Speaker of the Opposition has based her opposition on the idea that institutional arbitration in and of itself is not a complete solution. It requires certain supporting factors. For example, internal changes within the way PSUs handle arbitration, court support, reduction of judicial interference, proper legal representation. And to me, that is a curious proposition because, of course, the supporting conditions that allow institutional arbitration to function and be implemented are implied in the proposition. It's like saying exercise is a complete solution to staying fit. That implies that you have to wake up in the morning to exercise. You have to get a proper trainer who will support the exercise that you're doing. You have to choose the correct kind of exercise that is meant for your age and your body type, etc. And then you have to add that little protein shake at the end of your exercise, or as the younger generation now calls it, matcha. There has to be, in the proposition, an implication that when we are adopting institutional arbitration, we will adopt it with the paraphernalia of knowing how to function within the remit of institutional arbitration, whether it is on the judicial side or on the legislative side or within the PSUs themselves. And it is curious to me that we are comparing this as a proposition to ad hoc arbitration. To me, that is almost counterintuitive. Let's not look far. We're sitting in the hallowed halls of the Delhi Arbitration Weekend, which has been organized, and successfully, I might add, by a committee that is headed by the foremost judges of this honorable court, some of the most well-regarded judges, some of the most well-regarded senior counsel and counsel. There is a moderator right here who herself is a distinguished counsel, who has been keeping a watchful eye on the clock and explaining to us the rules of this debate. You walk a few yards from here, ladies and gentlemen, there is the Delhi High Court Registry. And for those of us who practice here, we know that it is a holy site that must be bowed to, that must be revered, that must be understood, and without whose blessing you cannot have a successful practice in the High Court. The registry manages all procedural aspects of all cases that are handled by the High Court. So between conducting an arbitration event and the disposal of important and by the dozens and probably by lakhs cases by the Delhi High Court, we recognize that an institution is required to provide logistical support, cost effectiveness, time effectiveness, and essentially to bring a dispute to completion. And yet, when we are talking about PSU money, which is public money invested in highly critical infrastructure projects, and disputes that emanate from that money, which are complex technical disputes, somehow we fall back a minute and begin to wonder whether we can do that without an institution supporting the dispute resolution process. To me, that is counterintuitive. And the statistics do not lie on this. You can pick up the DPIIT month-on-month data of FDI, the top performing sectors as in terms of recipient of FDI. And if you do a little bit of number crunching, which I've had the time to do for this debate, you will find that 70% of our 85 odd Maharatnas, Mini Ratnas operate in about the top 10 FDI receiving sectors. The Queen's Mary Survey on International Arbitration of 2025 tells us that 87% of all participants globally, and I mean foreign investors, prefer institutional arbitration as a mode of dispute resolution. So really, what choice do we have? If we want to develop institutional infrastructure and critical infrastructure within the country, then institutional arbitration is the only way to go. Just in response to some of the issues around time and cost that have been raised, the evidence around the length of an arbitration versus the length of a court proceeding is not anecdotal. The National Judicial Data Grid estimates that there are almost 5 crore cases pending across courts, with approximately 82 lakh cases pending for the past 5 years. If you pick up the 2024 annual report of the MCIA, which we should all be proud of because it is a homegrown institution, 91% of its pending cases were resolved within 18 months in the last year. None of those cases have been known to be set aside by a court. In fact, one has been recognized by the DIFC, which is the Dubai International Financial Centre Court. And then we can look at the international institutions. You look at the ICC. The ICC will tell you that the average time of an arbitration, and mind you, the ICC is the default institution in FIDIC contracts, which are highly technical contracts and largely adopted across PSUs, particularly for big infrastructure projects. 413 awards were rendered in 2024. They were rendered within an average of 26 months. That is only 2 years, ladies and gentlemen. And out of these 413, only 26 cases exceeded this time period by 3 months, and yet the ICC imposed reduction fee on the arbitrators for delays in 57 cases. So, vis-a-vis time, there is no dispute that institutional oversight brings matters to a conclusion, follows up with arbitrators, has the mechanism of reduction of fee, and more importantly, has an institutional memory. The institution will remember how well an arbitration was conducted and whether the award was rendered within the precincts of the rules and within the time that was allotted within the rules. So over time, the institution fine-tunes the selection of the arbitrators, and that is the best that you can hope for in a system which is largely confidential and party-driven. And finally, on the point of expenses, time is valuable when you calculate money. It is every monetary transaction has a time value. So the moment you say that something is expensive without allocating for the fact that something is also time effective, that proposition doesn't hold. And more importantly, interest liability compounds in arbitrations. The best of us know that. Most big PSU cases involve a serious interest component, which can seriously be curtailed by simply following an institutional format and resolving the arbitration within a small period of time. Finally, on the point of mediation, the proposition is simply that institutional arbitration is an effective dispute resolution mechanism. It is not that it is the only dispute resolution mechanism. So mediation.
Question basics where it lies. Why do we always, pinpoint this is a latent defect in you, this is a pertinent defect which is highlighted, and that is why PSUs are in the wrong, the people making the decisions are in the wrong, and therefore an institutional arbitration seems to be the only recourse which is available. According to me, we are not addressing the elephant in the room. When we talk about institutional arbitration and we say it's come about to replace ad hoc arbitration, for me it's like putting old wine in a new bottle. And I agree, I am making a slightly controversial statement to that effect. but what's the fun of it if it's not done? And let me make good my point, at least attempt to. So what happens is, when I as a PSU, as litigation, going to a court of law, take a commercial court for example, has a trained person at the helm of affairs, what is my cost involved? I pay the lawyer there also, and I pay the lawyer in the arbitration also. That's a win-win situation for all of us. And trust me, it's a win-win situation for all of you who will be participating in these proceedings. The thing is, why this perception? When we want to get in, we are always scared about entering into arbitration, and an institutional arbitration is a complete no-no. Why is this? None of us want to address this issue, but we want to critique and criticize pending situations which are prevalent. It's very easy to critique a court, but I still believe for a PSU, see what happens for a PSU is, imagine it's functioning. These memorandums have come in after a detailed inquiry as regards the functioning of the courts, vis-a-vis what was sought to be created. That is, arbitration was sought to be created as what? An alternative, effective dispute resolution mechanism, which it has, unfortunately, in terms thereof, completely failed. The costs have gone up. Even in an institutional arbitration, there is a dual cost involved. Not only is the fee of the arbitrator, fee of lawyers, of course, remains common. Institutional arbitration cost. Vis-a-vis a person, and why a PSU alone? Even an individual going to a commercial court, to a civil court, what is the aspect of cost involved? Delays are happening in every field. So if the problem is delay, then please address the problem of delay. But saying institutional arbitration is the only recourse, I'm sorry, does not work. We are pushing the problem. We are not addressing the issue. Secondly, for an institutional arbitration, what is an institutional arbitration? We say the institutional arbitration just replaces the court. At that stage, becomes the court for adjudication, in place of a person who's been trained, who takes care of so many factors. You know, when a person is sitting as a judge, he or she, at that point in time, addresses so many issues. As a lawyer, when you address, you take care of a client, you take the human side of it also. For a PSU, there are various decision-making processes. Actually, just let's go of everything, and the PSU can be brought down to its knees for nothing. So the problem lies fundamentally not only in the issue of cost, which in fact is huge, but is also secondary in terms of a perception which is available to a PSU and a correct perception in law that I'll be protected in terms of that litigation. There is someone still looking out for me. I'm making this statement realizing that there will always be a counter argument coming. Article 14, there should be a level playing field. Yes, there should be a level playing field, but for parties who are equally placed. What we do is, when we make it into a counterparty adjudication, we actually put that PSU or that individual to a kind of a disadvantage. The recourse is in terms of an appellate mechanism. The appellate mechanism is evolved for ad hoc also and lies the same for institutional also. Is the challenge which is put in. The 34 challenge is so restrictive in nature that whatever be the fundamentals of an award, 9 times out of 10, it is impossible to succeed in that kind of an evolution. The evidence which is led, the cross-examination which is detailed out through a detailed litigation process, safeguards public money. And that is where the fundamental issue of protecting PSU safeguards comes in. This is where the decision is coming. We want that these institutions should come up. We want arbitration as an alternative mechanism. And firstly, why not mediation? Settle the disputes therein, if at all there is anything. Why is there a requirement for an arbitration clause? What does the arbitration clause do? We don't address this issue, but we come up and say institutional arbitration is the best forum. Let's go and address issues there. What does an institutional arbitration do? How does it help? How does it address the issue? Is something fundamentally nobody is wanting to address. And yet coming up and saying, well, this seems to be the only plausible explanation for coming up and saying, comes as an ultimate solution. My learned colleagues and the speakers at the other end have mentioned about case studies Well, there are replete case studies completely opposite. There are replete case studies which all of us, including me, have had the best side of arbitration on one hand and the worst side of arbitration on one hand. It is impossible to collate, and which will always be the case, whether it is litigation, arbitration or otherwise. But then to come about and say institutional arbitration seems to be the only effective mechanism is completely incorrect, because we are not at all addressing those issues as to why arbitration in itself, and that debate being made towards ad hoc or institutional, has come about as such a perception that it is failed. And for an individual or a PSU to take up that initiative and say, well, I don't want to go to an institutional arbitration at all, maybe to a Section 11 arbitration recourse I take, or otherwise I end up being in litigation, because ultimately, whatever be the result of the matter, it always ends up in a detailed litigation process, which is through the appellate remedies, and it flows accordingly. There are solutions, but those solutions have to be looked at from within, and at this stage, I believe that PSUs should not be put down, and there is no solution saying that institutional arbitration seems to be the only recourse open to PSUs in terms of effective adjudication. And so my prayer, the tough one, we've already lost the vote, but hopefully some of you will change their vote and help us in proving that this topic is actually completely misplaced, and institutional arbitration is not a complete recourse to PSUs resorting towards arbitration. Of course, there are many in the panel, and we're already getting looks from people who invited me here. Shashank is one of them. But I rest my case at this, and thank you so much.
But also because that's what the state tells us. The state tells us that it won 2, as Brar mentions. And my friends on the other side refer to cost. You know, Patch Adams once told us, you look at your finger like this, you see 4 fingers. You look carefully, you might see 8. The point is, you look beyond what is obvious, you look beyond. And it is in that context, may I make a few very basic points. But let me start with a poem that T.S. Eliot wrote in the aftermath of World War I. And it starts thus: between the idea and the reality, between the motion and the act, falls the shadow. The idea is, we have this beautiful system of alternate dispute resolution, which is founded on the principles enshrined in sections 18 and 19. Party autonomy, equal treatment. You move away from the trappings of the processes that have tied us down. And then you get into a space where you expect those who lead by example to set systems in place so that the processes work. And that's something that we did from 1940, 1996, 2015. And please note, 2015 is a watershed moment in the Indian legal firmament, because you have amendments to the Arbitration and Conciliation Act, and you have the Commercial Courts Act being enacted. What was the message that the government of India was sending out? What was the message that the legislature sent out? Here is a landscape. Both are equally good, and these two mechanisms will compete with each other to help you find the place that you're most comfortable in. And it comes in the backdrop of, you were uncomfortable with the civil court system in the first place. And I just heard Mr. Bhan say, perhaps the open court process may be a slightly better alternative today. None of us says that in institutional arbitration is the only solution. The reason we talk about this topic today is that the only means to provide a complete solution in the space that we operate today, to restore faith that has been lost? And I'll tell you why that faith has been lost. Because we all forget Article 51. You heard somebody say, one person in an institution can lead to various problems in an arbitral process for an institution. But is that the problem? Or do you have to find a solution? So we now take 3 things. An institution, because it is a public sector institution, is floating all over everybody. Then you have problems in the process of decision making. Time and again, in the ordinary litigative process, we have seen the state being treated differently on basic issues as limitation. And courts have taken judicial notice of this process and this fact. What does institutional arbitration do? It takes the fundamental headaches out of the equation, which is what? Your dispute, how best to prepare for it, find the right people and take it home. It's not that PSUs don't have good people. They're equipped, they're well equipped. The problem arises because you take a decision and there is always this looming threat of something or the other going wrong day after tomorrow, or on the date of your retirement you suddenly receive a vigilance notice which keeps your pension hanging. That is a process that is linked to a decision taken by an individual. An institutional arbitration process takes away that entire gamut of responsibility. What it also does, it does help us as a country. We are ultimately dependent then on our own performance individually. And that's why when you hear about the MCIA, when you hear about the DIAC, these are institutions. I mean, as Ms. Brar said, the Delhi High Court Registry, the quantum of work that it handles, and the fact that we are the only court in the country that can deliver a filing within 24 hours. You are guaranteed a listing in this court the next day. This is an institution. So institutional arbitration does a few things, and that is precisely why we feel that if you take the headaches off your back, focus on what's important, an institution does a few things and it helps it to also generate, as Ms. Brar says, muscle memory. So you have an institution which then, first attracts people because it is credible. The entire edifice of this entire conversation is founded on what? We want a dispute to be resolved in a neutral manner by somebody who's impartial, and which results in an outcome where we hope that parties will walk away without feeling the need to challenge. And please take it, it is reflected in our judicial processes. There are judges and there are judges. There are judges whose orders are passed, they're speaking, and very often a party says, there's no point taking this up because when you mention who the judge is, the appellate court is not going to even look at us. That is a process of demonstrating credibility. So 4 basic points. The crisis is really of confidence. It arises because of our own failings. And when I say our own, I mean the PSU. But it is endemic of the system. Number 2, is it therefore right for us to look at a time when we go down the process of building institutions? Please remember 1947 when we became independent, we built institutions which were called institutions of modern India. We may have to revisit history a little bit and focus on what's important. Number 2, cost. You focus on the cost that you pay every day for arbitrations, but you don't focus on the time, energy that you spend on a dispute which can in fact be resolved, closed, and becomes the benchmark for future conduct. Time and again courts have commented on the government's, and I use the expression, insouciant attitude. Not my words, this is the Honorable Supreme Court. It is that aspect of the matter, ladies and gentlemen, that is the subject matter of the debate today. What are your options? A court? We know they're already overburdened. Mediation? It's fantastic, but again, it calls for somebody to take a decision. This entire problem arises because somebody doesn't want to take a decision. And which is why you have rules which say you mediate, but ultimately you get that converted into a consent decree. But there is still the crisis of confidence somewhere looming large. And then of course, thirdly, the process. The process is the punishment more often than not, particularly in ad hoc arbitrations. I'm not for a moment suggesting that institutions are also great. They have their own failings, but at least they've demonstrated that there is a way to be. So it eliminates part of the process, it eliminates some of the pain and the punishment that you endure during the process. And then more importantly, it helps you discharge the most fundamental thing that you are expected to do as PSUs, the doctrine of public trust. You discharge your fundamental responsibility. And in the process, you add to 2 C's, being Viksit Bharat. You must first fix it Bharat. So therefore, please look at institutions. Institutions help build processes. Those processes help tailor conduct. That conduct which leads to consistent conduct leads to confidence. We must all endeavor, and I hope the government leads by example through the PSUs, to find a way to identify the right arbitrators. If you can't, let the institution do so. If the institution can't find the right institution, and it is in that process that you will find that that faith which was misplaced and therefore lost will be regained and restored. Thank you.
Good evening. Respected jury, distinguished members of the House, and that, ladies and gentlemen, is important for us to remember before the next show of hands, which I'm hoping would be better. The topic that we're debating is that institutional arbitration is a quote-unquote complete solution to the PSUs arbitrating in India or abroad. Now, I haven't heard from any of my friends as to how is it a complete solution, in what sense. I'm reminded of an anecdote that Mr. Nariman, who we all revere, once said. And he told us that there was a signboard in the window of a shoe repair shop in downtown Boston. The shop was run by a Greek immigrant who was fed up with the complaints of the consumers. So he put up a sign in a triangle connecting three expressions: fast service, low price, high quality. At the top of the triangle were the words fast service. At the bottom, at one end, low price, and at the other end, high quality. The customers, however, could only choose two of the three. They could not pick up all three of them. That, ladies and gentlemen, is the problem of arbitrations in India today. I am not for a moment suggesting, as my good friend Mr. Bhan did, that we should not be arbitrating at all. But that I respect that view. It is important for us to debate and understand his point of view. But how is it that the institutional arbitrations can address all the three of the points, that is fast service at a low price and of high quality? Now let's go next to the process of arbitration. Our Act, 1996 Act, which may require a few tweaks here and there as we go along, is prescriptive of a procedure that an arbitration follows. It defines a time frame within which a proceeding is to be concluded. It defines timelines for filing of pleadings. And it leaves it to the tribunal to decide the rules of the game, the final rules of the game. Now, what is it that that an institution can do in the process, deal with the process of arbitration than in an ad hoc tribunal? Ladies and gentlemen, at the end of the day, it is in the hands of the tribunal that the process needs guidance. And a good tribunal, whether ad hoc or institutional, would ensure that the arbitration proceeds in a proper way. But the question I ask myself again, and on something that you will be voting, as to how is it that an institution is a complete solution to a better arbitral process than an ad hoc arbitration. Let's come to the third aspect, the third stage, the award stage. Is there a data that my friends have cited that an institutional award is better than an ad hoc award? An institutional award is required to be given better credence than an ad hoc award is required to be given. I haven't heard any of my friends on this. In fact, there is no empirical data available. And ad hoc arbitrations are hardly inquired into or compiled as a data. What we know from our experience as lawyers and as arbitrators is that an award is as good as the arbitral tribunal. An institution could also appoint a bad tribunal, writing a bad award. An ad hoc tribunal could be equally bad or good and writing a good or a bad award. Institution doesn't change. So how is it that you are going to vote on the motion, for the motion, that yes, the complete solution is an institutional arbitration? On what yardstick? Please don't vote by your feelings. Please vote by your experiences. Fourth stage, post-arbitral costs, challenge to the award. Is there a data that my friends have given you that in respect of awards that have come out of institutional arbitrations, challenges have been less and lesser interferences in those awards by the courts? I haven't heard them on that. In fact, there is no such data available that an institutional arbitral award would have a better day in the court in terms of sustenance than an ad hoc award would. So where are we? None of the four stages of an arbitration really find, as of date, that an institution is better equipped to handle the situation than an ad hoc arbitration is. Please don't mistake me for arguing the proposition that I am propagating no institutional arbitration. I haven't said that. What I am propagating is that institutional arbitration can't be one suit that fits all. The proposition that my friends would have you believe is that please vote that the PSUs must only arbitrate institutionally. That, ladies and gentlemen, is one suit that can't fit all. Coming now to the memorandum that has led us to this debate. Government and PSUs are litigators, and perhaps the government, as the data tells us, is the biggest litigator that we have in the country. As the biggest litigator, it is entitled to have a point of view. That point of view must, of course, has to be reasonable. It must be born from genuine experiences, and I agree with some of my friends on the opposite side, and Ms. Chawla and Mr. Bhan, that the importance of ensuring that a process of adjudication, like arbitration, is effective, is efficient, is to ensure that you present your case in the best manner possible, and to have a say in the appointment and in the process of arbitration. How do we ensure that in an ad hoc? You can have, and surely my friends on the other side would not deny this, you can have party autonomy, party choice of selecting any rules of arbitration in an ad hoc arbitration. I can have an ad hoc arbitration under the aegis of the DIAC rules, but it may not be a DIAC arbitration. Nothing stops. And that brings me, ladies and gentlemen, to a very important aspect that my friends perhaps wanted to, but the time did not allow them to comment on. And that's the principle which is the bedrock of arbitration, and it is party autonomy. How is party autonomy better served? Please ask yourselves this question. How is party autonomy better served in an institutional arbitration versus an ad hoc arbitration? It is my respectful submission for you, and I would commend for your acceptance, that it is not that an institutional arbitration would serve the cause of party autonomy better. Having said that, may I just hedge with a comment here, and that is that the proposition that I am advocating is not that an ad hoc arbitration should always be the default mechanism or is best suited, but an ad hoc arbitration which is suitably structured, keeping in mind the principle of party autonomy, should, according to me, be the best solution. What ails the PSUs in their cases is, of course, apart from the fact that part of the issues that my friends have pointed out, is also lack of preparation, is also lack of presentation, and is also unwillingness to take a call at the right time. A stitch in time saves 9, but a stitch in time is hardly seldom ever taken. We have all experienced institutional arbitrations, we've all experienced ad hoc arbitrations, and I've had experience of both as a counsel, as an arbitrator. And may I say this, while there is a bit of hand-holding by an institution, but that does not mean that hand-holding is so fundamental to the process that without that hand-holding of the tribunal, the process would be dysfunctional. So ladies and gentlemen, I will end by saying that please look at the proposition. The proposition would have you believe that the only way is institutional arbitration or the highway. That is, with respect, a suit that cannot and should not and ought not to fit all. And I request you to reconsider your vote and vote against the proposition.
Remarks. One of the aspirational and oftentimes rare sights in both arbitrations and debates is strict adherence to timelines. And I must compliment the speakers today for setting the gold standard. Let's now reward them by moving to rebuttals. This is your chance not just to defend but dismantle. Let's begin with the side supporting the motion.
When I listen to my esteemed friends, I think they have all forgotten that the horses have bolted, the PSUs have left, and the topic is how to bring them back. It's not about how institutional arbitrations are better or ad hoc arbitrations are better. It is how to bring them back into the fold of arbitration. That, my friends, is the question which you have conveniently ignored to answer. You said I didn't give you facts. I'll give you some facts. MCIA has had several arbitrations, but not a successful challenge. When an institution administers an arbitration, it does not mean that it won't be challenged. Of course, there must be a challenge to every award, but that does not mean that arbitration itself that is administered by an institution has failed. What it actually does, it gives a proper framework, and I'll tell you how. ICC, SIAC, London Court of International Arbitration, MCIA, all have a mechanism of review of an award. When we say review of an award, it does not mean that the award is reviewed on facts, but it is reviewed on form. And it is sent back to the arbitrators if there is a deficiency in form. Because you don't want a challenge to be successful. At the same time, you want to ensure that arbitrators have decided, taking into consideration all the facts. So when they look at form, it ensures that the form is in such a manner that it would be acceptable and palatable to a court, which is exercising jurisdiction under 34. That is an important circumstance, and that is what an institution does. I think there is a conflict, of course, between the three speakers. I didn't see it amongst the one speaking for the motion. Ms. Chawla says we must have arbitrations back to where it was. Just bring it back. We just want ad hoc, institutional, doesn't matter, just bring it back. Mr. Bhan says, forget arbitration, let's go to court. We've had enough of arbitration. And in between one of these is, of course, Mr. Mehta, who has focused entirely on trying to find gaps in reasoning that we have given, but not actually giving you any other facts which show that what we are saying is untrue. Therefore, if I was wondering, complete solution to restore the faith. It is not simply complete solution. No one said it's a complete solution. No, nothing in life is a complete solution. You need to look at litigation as well. In some cases, you must go to court. It's not that for everything you go to arbitration, but then you must bring them back. Because let's be clear about this. If all these cases which have been resolved by arbitration over the years were to go to courts, maybe it's 3 years, maybe it's 5 years in arbitration, but it'll be 15 in courts. And by the time they're over, the ones who will suffer are the ones who go to court are the claimants. And therefore, the opinions of my learned friends are really of a kind which is done to pick holes than to actually state facts. There was another factor which Mr. Bhan spoke of. He said it's old wine in a new bottle. But I think Mr. Bhan knows that arbitration is maybe as old as civilization itself. And form today is only different in terms of the acts. And therefore, The bottles and the wine are both old, Mr. Ban. Party autonomy. The Arbitration Act, by its amendment, says we must focus on institutional arbitration. That's the stated point of the government. That's the stated point of the legislature. Then you wonder why PSUs are told to walk away from arbitration. Therefore, there must be a big divide between what the government believes should be as arbitration in institutions, and then say, but for PSUs we must walk away from arbitration. There obviously is something, and that is what we as speakers for the motion have pointed out to you and told you, that there is a problem, and the problem is in ad hoc nature of arbitrations, which you must correct. Party autonomy is achieved when you agree on a set of rules, when you agree that you will abide by those set of rules, and if the award is wrong, of course you must challenge it. No one said you can't challenge an award. And therefore, I think, as I stated right at the start, the motion is clear. There is only one answer. The answer is not to go back to litigation. The answer is to arbitrate. And the only way you can arbitrate after the horses have bolted is to try and bring them back into the fold. And to bring them back into the fold, you must look at institutions of credibility and substance. Thank you very much.
Not to the gaps between the three of you, there are many, and I could have gone on, but I was speaking gratis and for 10 minutes. But I was reminding you of your silence on facts. And when I say you, I meant the proponents of the proposition. I haven't yet heard, even in rebuttal, a single fact. And that takes me to a beautiful couplet. Allow me to recite it. Those of you who can't follow Hindustani, I'll explain to you in over tea. But it goes like this. And this is about your silence. मेरी बात का मेरी हमनफस तू जवाब दे या ना दे मुझे तेरी एक चुप में जो है छुपी वो हजार बातों की बात My friends, the silence of the proponents of the proposition speaks it all. Now, coming to the specifics. And awards rendered, institution versus ad hoc. What we find is my good friends haven't told us as to how and in what circumstances is an institutional arbitration faster. Ms. Chawla told us that the facts as they are that only 10% of arbitrations in India are institutional, 90% ad hoc. The data is anecdotal. We don't know. So can you say with conviction that they are faster? I have my doubts. Next, Mr. Chinappa gave us 3 case studies, and of course they were very instructive. But I was wondering as to how in any of them an institutional arbitration would have held better. If an award is bad, it is bad irrespective of which institution it came from. If it is good irrespective. Then he told us that remove the arbitration clause. And I was still wondering as to why have they not put in the institutional arbitration clause if institutional arbitrations are a complete solution. We don't have an answer, ladies and gentlemen. Then he told us something very important, and I agree, that most fundamental aspect of arbitration is appointment of the tribunal. I agree. But how is an appointment by an institution different or better qualitatively than an ad hoc appointment? We don't know. Ms. Brar told us that an institution has an oversight mechanism. They know as to which arbitrator is rendering awards in how much time. But would they know which award is better and which award is not so good? And if they would, how are they a better judge of who your arbitrator should be? There is a gaping hole there. We don't know. How can you trust blindly an institutional oversight to say, well, if SIAC is appointing an arbitrator, he must be good. If ICC is appointing an arbitrator, he must be good, or she must be better. But if a Section 11 court is appointing an arbitrator, my God, death knell. On what basis? We don't know. Then my good friend Mr. Rao's told us, you got to have faith. Is your vote. And what the proponents have done to gain that is to be excellent lawyers, and all of them are. They haven't told you anything about the proposition. They have charmed their way through your heart, and they would want you to vote for the motion. I'm not as charming as they are. Much of my charm is gone anyway. But I want you to think of facts that I have given you, and I can challenge them more, and vote against the proposition. Thank you, and have a good evening.
We now have the case built, challenged, and defended. Before we advert to our esteemed jury, it's time to take the House vote again and see if any of the teams have been able to charm their way to your heart or swing the votes in their favor. I invite the audience once again to vote by show of hands. Those voting still in favor of the motion, please raise your hands. Those voting against the motion, please raise your hands. Wow, we have a split house. Thank you, ladies and gentlemen, for giving us the House verdict, or the popular vote, as some may say. But as in arbitration, the final word and value lies with the tribunal, aka the jury, and their reasoning. Having witnessed the richness of perspectives in this debate, we now look forward to the considered reflections of our jury. May I now request Dr. Anju Rana to begin with the jury's closing observations.
Good evening, ladies and gentlemen, and the esteemed speakers. This evening we had witnessed a debate that has been spirited, engaging and illuminating. The motion before us touched the very core of how arbitration is understood and practiced in India. The arguments we heard highlighted the central tension whether institutional arbitration can truly serve as a complete answer, or whether the complexities of PSU's disputes demand a more nuanced approach. What has stood out in this exchange today is not just the strength of the arguments, but the seriousness with which each of you approached the motion. This has not been a contest of rhetoric, it has been a genuine effort to grapple with the future of arbitration in our country. What struck me the most is that it surfaced the questions that matter most for India's arbitration ecosystem. How do we build trust? How do we expand access? And how do we ensure quality in every award that is delivered? The truth, ladies and gentlemen, as always lies in the balance. Institutional arbitration has the potential to become the backbone of dispute resolution in India, but its success will depend on building capacity, broadening access, and ensuring the quality at every stage. Trust will no doubt endure when awards are consistent, impartial, and respected, and when parties, especially PSUs, see institutions as partners in justice, not as distant or rigid framework. As judges, our role is not to prescribe solutions, but to reflect on the richness of what has been argued. And today, the quality of discourse has given us much to carry forward. I truly appreciate and thank our speakers for their thoughtful arguments delivered with clarity and conviction, our audience for their keen engagement and their votes, which added weight to this evening, and the organizers of this debate event. With these words, I again thank the organizers for inviting us in this event. Thank you so much. Jai Hind.
It is my absolute pleasure to now invite Honorable Justice Devendra Kumar Upadhyay for his observations and closing remarks.
Honorable Justice Gupta, the participating debaters, the audience. As a member of jury, I suppose I am not to speak on the topic. As it is, I was just sharing it with Justice Gupta that judging a lawyer in the court and judging them outside the court are two different ball games. So a very difficult task was assigned to us, but I am happy to listen to the very, very illuminating arguments on both the sides. I would not comment right now because I have to be part of the verdict ultimately. But I would suggest only two things. Not suggest, but I want to observe. One, you know, in the beginning of this program, the audience vote was sought. Most of us sitting here voted for the motion. What does it indicate? The PSUs are going away from the arbitration. What does it indicate? That the present system of ad hoc arbitration is perhaps not working to the satisfaction of the participating parties in the arbitration process. So that's one. And secondly, the dichotomy pointed out by Mr. Rajshekhar Rao, that look here, it's parliamentary enactment enacted by the Government of India. It is all for promotion of arbitration process. We keep on hearing day in and day out that India needs to become arbitration hub. So thirst in this area, and then the government's notification asking the PSUs to back out from the arbitration. So this dichotomy needs to be solved. That's all I have to say. Rest, I'll be part of the verdict. Thank you.
Thank you, sir, for your insightful observations. I would now request Honorable Justice Gupta to conclude the jury's remarks.
Actually, this podium is for the motion, so I will take it that way. As a chairperson of an institution, it is my duty and responsibility to support motion. What has been told by both sides means a lot of truth is in both sides. It's not that, the ad hoc arbitration is absolutely bad or institutional arbitration is a complete solution. But as Mr. Chanappa has said, that it is to restore confidence of the public sector undertakings, the attempt should be made. Now the difficulty is the Government Office Memorandum of 3rd of June 2024 was issued on the basis of experience of ad hoc arbitration. As of now, institutional arbitration is not prevalent in India. As pointed out, 90% of arbitration is ad hoc. So ad hoc arbitration is not inspiring confidence of public sector undertakings. That is true. I give you two examples, my personal examples where I am co-arbitrator. One arbitration started in 2012. The matter is still pending. And ours is the third tribunal. Two tribunals, one tribunal was superseded by the order of the Supreme Court, the other one resigned or dissolved. So we are the third one. So arbitration dispute which initiated in 2012 and 2025 is still pending. That is the stage of ad hoc arbitration. And as has been pointed out, that time is money. If a claimant loses money, the money value has gone down. The public sector undertaking has to pay, public sector undertaking has to pay out of public funds. So both are losers ultimately. It doesn't serve anybody's purpose. As has been pointed out by Mr. Jayant Mehta, that empirical data is not available. For his information, 11.6 applications. In 2022, the data was called by Supreme Court in one of the matters. 4 high courts had more than 3,011.6 applications pending, including 800 pending of my parent high court. There was Bombay was pending and Karnataka. They were the other high courts with a large number of applications. None has touched 1,000 mark, but less than 1,000 marks. So ad hoc arbitration has probably not yielded the desired result. I give you an example. As pointed out, there is no data because no data is published of arbitration. Because of the confidentiality, no data is published. The task was given to Arbitration Council of India, but it has not come into existence. So there is nobody that none of the institutions are conducted, except one law firm has collected some data of ad hoc and institutional arbitration. But that is again not very sure that how far it is correct. Now I will give another example of our institutional arbitration. We got one arbitration. We could find somebody in Kerala to conduct arbitration. The parties were happy. We were regulating it from Delhi, but the parties were there, convenient for both the parties. Then other arbitration was from Bangalore. So the party wanted somebody from, it was not a large amount, but contentious issue. So we could appoint somebody from Bangalore as an arbitrator. And last week there was another dispute from Ranchi. And the party wanted, our attempt was that we should give an arbitrator from Ranchi who can conduct arbitration disputes. So that is the advantage of institution where you can choose somebody from that from that area. In ad hoc arbitration, say if Delhi is appointing an arbitrator, the resource is Delhi, within Delhi only. It doesn't have the resource of Calcutta or Bombay, or like Bombay will have the resource of Bombay only. So there is a limited resources available in respect of the high courts because there is a territorial limit of those courts. But as an institution of pan-India presence, we are everywhere. We can conduct arbitration and we are doing arbitration of different levels. The confidence of the people, ultimately is a perception of the people that how good or bad the institution or ad hoc arbitration. The people perceive, the litigants perceive, the disputing parties perceive that institutional arbitration is a better option than the ad hoc arbitration. I think that is the biggest flag of the institutional arbitration, rather than some argument here and there that the lawyers can be forceful. They are forceful. They could convince some additional votes, but that doesn't mean that the perception of the people have changed. Perception of it is the litigant. For a lawyer, the litigant is the biggest advertiser. If the litigant feels that institution is a better arbitral institution, that's good enough. The perception of some lawyers or some persons here and there won't matter. So, and again, a day before there was a news item. In Visakhapatnam, they have opened a new arbitration center. Meaning thereby that more and more state governments are opening arbitration centers within their state so as to promote arbitration. That will mean that the people have confidence in the institutional arbitration. That's why the people are opening. We have institution in Hyderabad, institution in Mumbai, institution in Bangalore, and the institution in Delhi. You know, they are different institutions where people have confidence in. Delhi International Arbitration Centre is probably one of these success stories. More than 5,000 cases are filed every year, so it is as good as a court. And therefore, I would say that institutional arbitration is the only answer to inspire confidence of the litigating public, including the public sector litigants. With that, I thank you very much.
Thank you very much to our distinguished jury for those insightful reflections. On behalf of the IIAC and everyone present here, we are truly grateful for the time, thought and wisdom you've shared with us. Please join me, ladies and gentlemen, in giving our jury a warm round of applause. It is now time to present a token of our respect and appreciation to the esteemed jury and participants. To do the honors, I first invite Mr. Anant Vijay Palli, part-time member IIAC. So we'll be facilitating Honorable Justice Devendra Kumar Upadhyay and Honorable Justice Hemant Gupta. Can we have a huge round of applause, please? I now invite Mr. Ganesh Chandru, part-time member IIAC, to felicitate Dr. Anju Rathi Rana. Can we have the applause going, please? I now invite Mr. Naveen Kumar Singh, CEO IIAC, to felicitate the speakers for the motion. I finally invite Mr. Vinay Kumar Sanduja, Registrar IIAC, to felicitate the speakers against the motion. Can we have a huge round of applause, please? Mr. Sanduja has been working round the clock for making this event a success. So, thank you. With that, we bring today's debate to a close. The vibrant discussion, rigorous arguments, and keen observations with a touch of humor that we witnessed today are a testament to the growing maturity and promise of institutional arbitration in India. Let us carry forward these ideas, challenge the status quo, and together strengthen faith in arbitration as the true and preferred mode of dispute resolution. To formally conclude the proceedings, I now request Mr. Naveen Kumar Singh, CEO of IIAC, to kindly deliver the vote of thanks. Mr. Naveen Kumar Singh brings over a decade of legal, corporate, and ADR leadership experience. A strategic and visionary leader, he has played a pivotal role in strengthening IIAC as a premier institution for efficient domestic and international arbitration. May we have a huge round of applause for Mr. Kumar, please.
Good evening, and thank you all for being here today to witness this such a wonderful debate. On behalf of IIAC, I am here to convey our heartfelt gratitude to everyone who made this event possible. I remember a story when I was there in-house officer as an arbitrator. So there was one arbitration in which a senior most officer was an arbitrator. The claimant side, when they submitted their argument, then arbitrator told me that, look, what the claimant is saying, they have a point, and I should give a word in their favor. Then I said, sir, just wait, then we have to hear the respondent side argument also. Because both the sides were represented by a senior lawyers. Then when the respondent side concluded their argument, then he was saying, you know what, I was initially thinking that what the claimant case was, now I find that his case is not so strong. Then I am confused. So equally confused this audience was, because at the start of this particular debate, I think 80 or 90% vote was in favor of the motion. When the debate was concluded by the speakers from opposite side, then many of audience changed their mind, and then it is a split verdict, 50-50. So for this, I thank the jury, because at that point of time, that arbitrator was not a legally trained mind. So today we are having honorable judges, Chief Justice, Delhi High Court, former judge of Supreme Court, and law secretary. Such a distinguished jury, but still I find that they are also not clear what to say. So I just give my own reflection when I was an in-house counsel. Why I am thinking, it may be because the Justice Gupta, when our chairperson say that I may be biased, but I also, being an in-house legal counsel, then what the PSU legal officer will do? He will call that their impaneled lawyer and law firms asking the names. The law firms to whom you are asking the name, that law firm will that legitimately expect that the matter will come to them. Then they will suggest 2-3 names. There also you are just confused that to whom you will appoint this thing. That is the first problem. Then whatever the name you are suggesting, other side is not going to accept this. Then ultimately you have to file a section 11 petition. In any high court, when you are filing a section 11 petition for appointment of arbitrator, fastest they think minimum 3 months to 1 year you will take to secure the appointment of the arbitrator. We are talking here about the speedy justice. When you get the appointment of arbitrator in a 1 year time, what you talk about this? Because Arbitration and Conciliation Act said that arbitration to be decided within a period of 1 year. So there also that problem is. The second stage problem, once the arbitrator is appointed, then stage will come for the fee. How much will be the fee of the arbitrator? The PSU, when you put up a note for internal approval, will say that fourth schedule is the guiding factor after 2015 amendment. But the Supreme Court say that that is only a model thing. That is not binding. And once the arbitrator says this will be my fees, then PSU again face the dilemma what to do in this thing. When you are going for their internal approval, there that also issue will be there. So for all this thing, I believe that institutional arbitration is the answer. And this, because in the institutional arbitration, when you for selection of arbitrator, you will be finding a pool of arbitrators. From there you can choose that who can be your arbitrator. Appointment of arbitrator can be secured within a period of maximum 1 month. You will get that appointment of arbitrator. Third, the fee is already prescribed, that there is no point of negotiating with the arbitrator how much the fee and all. So this is that thing. So, sir, I thank honorable jury members. I thank the speakers for the motion. You have given us such a beautiful argument. Then I felt that, okay, wow, what I was feeling that they are conveying this thing. But that equally, when the opposite side, the senior lawyers, they spoke, then I also had a doubt that what to say. So this is the success of this event. So I thank the Honorable Delhi High Court, DIAC, to provide this such a beautiful venue for hosting this event. Even I thank my IIAC team members who have been tirelessly working to make this event successful, and I thank everyone. I thank the DAW organizing committee also to allow us to host this particular event as a part of this DAW event. And not the least, I thank all of you to be such a large number and make this event successful. Thank you very much. We are working and we are committed that we will make it as a flagship institution. Thank you very much. Thanks.
Wonderfully. And finally, a heartfelt thank you to you, our audience, who've been so engaged and so attentive throughout the event. We now invite you to join us outside for high tea, where the conversations can flow more informally over a cup of chai or coffee and a bite to eat. Thank you so much.